we are joined by MarkMonitor brand protection expert Brittany Shaw and our legal experts Thomas Peistrup and Jeffrey Sheldon. Thomas Peistrup is an attorney with practice balance between complex business litigation and corporate counseling. He serves dual roles in a private law practice with a focus on intellectual property counseling and litigation, also serving as in-house general counsel to Trey Milano, LLC, a mid-sized consumer goods company. Tom provides strategically driven interdisciplinary counseling in areas such as privacy, data security, and data breach, advertising clearance, IP portfolio management, international distribution, and risk management. Tom has a strong background in intellectual property and related fields, including copyright, trademark, trade secrets, unfair competition, defamation, and First Amendment defense. He has represented a wide variety of IP rights holders, including film studios, film and television production companies, broadcasters, music publishers, record labels, and print publishers, as well as companies in the field of direct response and consumer goods. Jeff Sheldon was the founding partner of Sheldon, Mack, and Anderson in Pasadena, and is now with Leech, Tishman, heading up the IP practice. His practice focuses exclusively on intellectual property law, including prosecution, litigation, and international and domestic licenses, as well as arbitration and mediation. Mr. Sheldon has been recognized as one of the 20 best IP lawyers in California. His leadership in IP professional organizations includes past chair of the California Bar State Bar IP section and past president of the Los Angeles Intellectual Property Law Association. Mr. Sheldon's technical background is in the biomedical and chemical engineering fields. He is the author of Practical Law Institute's best-selling treatise, How to Write a Patent Application, and is the professor for their 10-week series that taught people how to be a patent practitioner. Brittany Shaw has 5 years of experience spanning activities throughout the IP lifecycle from registration, licensing, and protection. She has partnered with global corporations in the pharmaceutical, collegiate, and fashion and luxury space to help create comprehensive brand protection strategies. Her current emphasis is leveraging big data through new technologies to connect dots to the physical world through tactics like rogue website litigation and providing qualified leads to law enforcement entities. So with that, I'll go ahead and turn things over to Brittany to get us started.
Great. Thanks, Gina. So today we're going to examine the overall landscape of 3D printing, how the technology is currently being used and adopted by both enterprise and consumer. We're going to have an IP discussion with our legal experts, Tom and Jeff, that were just introduced. And then we'll go over some recommendations of best practices, how to really stay on top of the challenges that 3D printing is going to have on the IP landscape. So let's kind of cover our bases. What is 3D printing? To me, 3D printing has always been kind of a mind-bending notion. I always think of printing as simply PC inputs to paper outputs. But technology has been revolutionized, and the Association of Corporate Counsel defines 3D printing as the process of making a three-dimensional solid object of virtually any shape from a digital model. So the process is an additive one, where layers of material are laid down in different shapes according to this blueprint. So you upload this blueprint. It's generated by a computer-aided design or some type of modeling software, and you slice the blueprint into digital cross-sections. So the printer then deposits the manufacturing material, whether it be liquid, powder, sheet material, etc., gradually, and it builds up layers until you have a 3D model that's complete. This really results in an almost identical physical article to the virtual model you input through the computer. And we're going to talk today a little bit about the landscape of this 3D printing technology. So when we examine the size and the forecast of 3D printing, you can see here that the market is expected to reach $8.6 billion by 2020, which is just a staggering number. A variety of materials are currently being used while it's still limited. So we have polymers, metals, ceramics. We talked about liquid, powder. And then the industries that are using it are really across the board right now. You can see the list before you here. But really, there are high entries to barrier really facing the industry. So, such as the newness of technology, there's unbuilt capabilities that are really preventing the technology being used for fully skilled products. And you can also see the drivers here. So there's efficient use of materials, reduction in human error, but it's a very expensive technology. That's why we're not seeing it be completely adopted very quickly. But 3D printing is really still gaining a lot of momentum and potential. So one of the big examples I want to highlight today is BMW. You see this headline that says BMW celebrates 25 years of 3D printing to build cars. This is just staggering. BMW was a very early adopter of 3D printing and additive manufacturing in general. And what they've been doing, so the majority of their use has really been prototyping, but they've also built replicas of historical race cars, and more recently, they've used the technology to manufacture engine parts. They've manufactured customized exhaust systems, and even this year, entire road-ready cars. So beyond car parts and prototyping, BMW has also printed prototypes for a one-of-a-kind wheelchair seat for the British Paralympics that are following the Rio Olympics this year. And what they've done is they've actually scanned the athletes' bodies so that the seat is designed around them, and it's optimized to be lighter, more durable, and more efficient for each athlete. Another relevant example, since we're talking about the Olympics, is Nike. Nike has worked with our U.S. runner, Allison Felix, as well as Shelly Ann Fraser-Price of Jamaica, who is the renowned for her 100-meter sprints. And Nike has worked with them not only to model a customized shoe for their feet, but also has actually manufactured the final products in the bottom of the shoe to adhere to the track better. So 3D printing is, while it's not widely being used in these companies, it's being used for very specific purposes that could very well be the norm one of these days. So let's talk about overall adoption. When we look at enterprise adoption in general, you can see the survey before you from 2014, and it shows that the majority of companies are still really in the exploratory phase. Prototyping is still dominating the current business use, and we've yet to really see it take over full-fledged production. Tom, I know you have had experience with some businesses using this for prototyping. Would you like to expand a little bit more on this slide here?
Sure. Well, I would just say that 3D printing is absolutely critical to the compressed product development schedules that we have now in place. As we know, a reasonably sophisticated consumer product can go from idea in its inception to actually being on store shelves easily within 6 months, and that's a reasonably sophisticated product with safety testing and the like. Not an F-35 jet fighter, but also not a hockey puck. And that the prototyping is really 3D prototyping is really critical, because someone will come up with an idea modification, and we can create a prototype within very, very rapidly, and then hold the prototype in our hands and see that a thumb guard may be necessary, or some safety feature may be necessary, or something just doesn't work right. And so the engineer can say, hey, why don't we put on a winglet at a 45-degree angle, and someone can run a new prototype off the printer, and we can take a look at the new prototype. So I just say that that's part of getting these products available. It mitigates the risk in terms of our design form and the functionality of our products.
Thanks, Tom. When we transition to consumer adoption, while overall adoption is still in the infancy, you can see a couple of studies show that it's about 5 to 10 years out for consumers really making a big push here. However, it's very important we still look at this. So it's important to keep in mind that the market may see an acceleration of that estimate as improvements to this printing technology take place. Siemens predicts that 3D printing will become 50% cheaper and 4 times faster in the next 5 years alone. So this isn't something that, while we look at 5 to 10 years out, that we can simply ignore. As somebody gets the ability to easily, quickly, and cheaply make an identical replica of any object, obviously this is going to have significant ramifications for everyone. So let's transition to kind of the impact on 3D printing now that we've set the stage on infringement and counterfeit. We've kind of discussed the landscape, so I wanted to throw, first of all, kind of a staggering number out for everyone. So you can see here that Gartner estimates $100 billion in IP loss due to 3D printing by 2018. That number represents 7% of total IP losses. And you can see that the industries affected are across the board. We have defense, automotive, healthcare, consumer, general manufacturing, supply chain, you name it. Every industry will feel the impacts. With that said, those who plan now will be best equipped to respond to these inevitable challenges on IP. So I'm going to transition over to Tom and Jeff here to really talk about the optimal legal strategy. How can we plan to prevent and combat this IP infringement that will be caused by 3D printing? So Tom, Jeff, would you like to take over?
Okay, I'm going to start with the optimal legal strategy. And the key is to start dealing with the problem before you have the problem, and start with the product design in a way to be able to get the type of protections we're going to be talking about a little further. Just as an example, add aesthetic features to your product that are not functional. So if somebody's going to counterfeit it, they can walk into some intellectual property which is available for aesthetic features. And seek all protection applicable. There's different types of protection, IP protection, that's applicable, and some applies to some products and some doesn't, but try to get it in place. And then once you're on the market, monitor the web to start looking for infringements and counterfeit product, which is going to become easier and easier to do now with 3D printing. So that's the overall optimal legal strategy, and it'll become clearer once we get into the details of how to proceed. So the types of legal protection available for products themselves are copyright, utility patents, design patents, and trade dress, which is a form of trademark. So we're limiting ourselves to the product itself. There's of course, almost every product has a trademark associated with it, but that trademark is independent of the particular product design. It covers a class of goods or goods that will cause confusion with your product with regard to the trademark. So trademark should automatically be done whether we're dealing with a product that can be 3D printed or not. But the four types of things that we're going to talk about are things that can protect product configurations. So that'll be copyright, utility patent, design patent, and trade dress. And the first one we're going to talk about is copyright. And Tom, you want to take the lead here?
Copyright applies to original works of authorship, and it is an automatic form of legal protection. It is secured upon creation of an original work of authorship. It is, that said, there are numerous benefits to applying for copyright registration with the U.S. Copyright Office, including the ability to file a lawsuit or to maintain a lawsuit, and the ability to secure attorney's fees. There's a number of benefits to copyright registration, including, as I mentioned, that it's automatic. It's relatively cheap or extremely cheap to register a work for copyright protection. I believe it's $55 to file online with the Copyright Office. Infringement is relatively easy to detect because an infringement is is typically visual, and you can identify it pretty easily. And MarkMonitor has some excellent tools for that. Takedown notices under the Digital Millennium Copyright Act are easy to generate. As we all know, the DMCA process can be extremely cumbersome and has a number of limitations, but it's certainly easy to send out notices and often typically have them acted upon. The remedies, once one secures registration, are very, very helpful. Attorney's fees are available, provided that one has registered the work and has a fixed notice. Copyright has an extremely long life. For natural persons, that life is the person's life plus 70 years after the person's, the copyright exists until 70 years after the person's death. For work made for hire, it is the shorter of 95 years or 120 years after creation. 95 years after publication or 120 years after creation. One of the great advantages of copyright registration is that a registration can then be recorded with U.S. Customs, and U.S. Customs can block infringements from entering the U.S. One thing that I would want to mention is that we've been working with Ryan Tucker at Strategic Services, and Ryan and Brittany are folks you should get in touch with if we want to talk about the recordation process. So, Jeff, I'm going to turn that over to you for the cons or the disadvantages of copyright.
There's a con, and it's built right into the copyright statute, which says copyright doesn't protect useful, functional things. And then you have the problem of what if you have something that performs a function, but arguably has copyrightable elements. Well, the Supreme Court dealt with this a long time ago in a case called Mason v. Stein, where somebody took a statute and made a lamp out of it, and then somebody copied the statute, got sued for copyright infringement, and the defense was, wait a minute, it's a useful article, it's a lamp, no protection. And the Supreme Court said just because you took a statute, something that was clearly copyrightable, and made something useful out of it, you're not losing your copyright protection. So where does that leave us? The courts have developed what we call a separability test. Can you separate the copyrightable element from the functional element? The challenge is different circuits treat separability differently, and the issue as to what exactly that means is right now before the Supreme Court. So it's not clear yet how far copyright protection goes for useful articles. I think it's pretty clear it will go for toys and it goes for games, but the case in front of the Supreme Court involves cheerleader uniforms. So how they're going to deal with that, don't know. Because if you don't have the right insignia, the uniform isn't very useful if it has the wrong team's insignia on it, but it's the same token, it is a useful article to show that you're a cheerleader. So it's going to be interesting how the Supreme Court works that out, and we'll probably have a new test for separability. So, but then the other problem is you do need a copyrightable element. I mean, you get a standard bolt or screw or airplane part. Where is the copyrightable element in that type of product? So we have three examples to sort of lay out the problem. Just sort of as a side problem, the issue sometimes arises, what happens if somebody takes my product and scans it in and creates a digital image? Is that copyright infringement? I think the better view is no, that's not going to be copyright infringement. It's not going to be prohibited. It's sort of, I'm basing it on a Supreme Court case that came out of California. California had what they call a plug molding statute that says you can't copy a product using a plug molding process independent of the patent. And the Supreme Court said, no, that's a state law, and it's impinging on the patent area, and you're preempted. California statute was declared unconstitutional. So I would think you're going to get the same result if somebody just takes your product and scans it in. So let's look at the particular examples. The first one has a green check mark on is an indication that is copyrightable. That's actually a copyright I did. I think it's called the Open Heart Design. It was a piece of jewelry by Jane Seymour, our client, and she, people knocked it off, and the copyright was an effective deterrent to it. This was before the days of 3D printing, but before they became practical. But I can see where somebody would use 3D printing to make this type of jewelry design. Tom, you want to deal with the other two?
Sure. The ribbon bicycle rack is sort of the classic example of what Jeff was calling the separability test that's applied by courts. And in this case, the ribbon bike rack failed that test because the court said that you cannot distinguish between the artistic elements of the bike rack and its utilitarian aspects. That is, you can simply looking at this bike rack, the curves of the bike rack are also utilitarian, and that's where you attach your bike and lock your bike up. So copyright protection does not exist for that for the ribbon bike rack. I also wanted to point to this the Penrose triangle, which is on the far right-hand side. This one is interesting because the digital file was posted on Thingiverse, and a DMCA notice was generated and sent by the person who created the digital file, and there was a great deal of hubbub about that notice. Now, and here we have another issue that Jeff has pointed to, namely that the digital file is copyrightable. It is a work of author. Can be an original work of authorship, and that can be the basis of a DMCA notice. That said, it is problematic if someone creates their own digital file based upon your own product.
And when you get the digital files, this is just my standard advice. When whoever's writing a digital file, somehow mark it like, the old maps, they used to mark it by putting streets that don't exist, so they know somebody copied it and didn't create their own. So put things, included the copyright notice in the digital file, and put loops that don't go anywhere, or silly names for things, so that it's very clear somebody copied it rather than did their own. So that covers copyright. Can we move on to the next one, please, which is utility patents? And I'm going to talk about, what a utility patent is and then the pros of doing it. And utility patents are the patents most of us are familiar with. You can get patents on products, compositions of matter, processes, arguably software, arguably living matter. And it covers the structure and use of products. So when you don't have an aesthetic feature you can go for, this is what you're going to come down to. Like on that bicycle rack, arguably they maybe could have found something on a utility patent. Generally, patents take a while, but if you're willing to write a check to the U.S. Patent Office, you can get what we call expedited examination. In theory, they'll get done within a year. So they can issue quickly, and there's a lot of foreign countries have what they call an innovation patent. China's one of them, where it's not rigorous. In fact, there's no examination to speak of. They go through very easily. A lot of them I've seen are just plain invalid, but somebody's got to spend money to fight them. And you do have a patent you can wave around with regard to counterfeits, and most people aren't going to be willing to take on a patent. So there are pros to utility patents, but unfortunately there are cons.
Yes. Yes, as most of us know, it's really difficult to enforce enforce a utility patent through a takedown procedure, notice and takedown, for example, through that MarkMonitor uses. And that's because, take eBay, for example. It's really difficult for someone at eBay to be able to determine whether or not, my widget is being infringed by someone else's widget. A patent actually consists of a number of claims, and to ask someone at eBay to be able to make that determination is really beyond the scope of what they're able to do, and it would simply not be reasonable. So they're rarely enforceable with takedown notices. The next disadvantage is it's often you have to actually take both products and compare them by the competing product, take it apart and look at it and see how exactly it functions in order to see if the specific patent claims are being infringed. Patents are typically very expensive to obtain, certainly compared to the $55 with the U.S. Copyright Office. Damages can be very difficult to establish. They're very expensive. Utility patents are very expensive to enforce. And there are a number of defenses. Patent litigation is not only extremely expensive, but once one brings a patent infringement lawsuit, you really open yourself up to some sort of invalidation proceeding. For example, an inter partes review, which is a new procedure that allows a patent to be challenged and invalidated through the Patent and Trademark Office. An example of where a utility patent applies is a hip replacement. We have a copy of a patent for a hip replacement over on the right-hand side.
And that's the type of product that would lend itself to 3D printing, and we're seeing it more and more in the medical field. Let me mention something on the strategy of patents. It's the old adage, protect the razor blade, don't protect the razor. So when you're began developing a legal strategy as part of the product development, concentrate on what the consumable is going to be, where the market is. That's why they give away printers nowadays, basically. And you can buy a printer for the cost of the refills because they want you to buy the refills. That's where the money is. So as part of the strategy, remember, protect the razor blade, not the razor. I think we're ready to move on to another type of patents, and this is design patents.
Yes.
Tom, you want to talk about them?
Sure. A design patent applies to the ornamental design of a functional item, and it can, ornamental designs of jewelry, furniture, and so on can be protected by, those can be protected by design patents. They're moderately expensive. Actually, Jeff, why don't you tell us a little bit about the advantages, because you're our patent guy. Why don't you tell us a little bit about the advantages of a design patent?
Okay, well this sort of fits, fills in where you can't get copyright, like that nice bike rack you showed, Tom.
Correct.
You the design patent on that. And they expense, typically you get one of these on file for under a couple thousand, less than $2,000. I consider that moderate expensive. More than copyright, but less than a utility patent. It's possible to get these quickly. We've been able to get them in as little as 3 months by jumping through some hoops. So, again, it's better to have it in place before the infringement begins and counterfeiting begins. But if you're still able to get a design patent, you can get it quickly to try to put a stop to the infringement. Infringement is relatively easy to detect. You can sometimes just look at the product, look what's up on the web page that's advertising it, and say, hey, look, that just looks like our product. That's infringement. So even somebody at eBay should be able to figure that out. The damages are generous, I guess would be the appropriate word, depending on your perspective. We're all pretty much familiar with the Apple versus Samsung case, where Apple got awarded over $400 million in damages on iPhone infringement. Most of that, if not of that, is attributable to the design patent. It has nothing to do with the function. And the statute says you get the infringer's profits. No apportionment for other features, just blank, get the profits, and that's what happened in that case. That said, that issue is right in front of the Supreme Court, and if the Supreme Court doesn't change that, then I would not be surprised if Congress revisits it. But right now, the damages are very, very favorable. So I kind of like design patents. Easy to get, great damages, infringement's easy to detect, a lot less cost in litigation than a utility patent.
Okay.
Tom, you want to handle the cons?
Sure. Some of the disadvantages are that you have limited protection for useful articles, and for that, let's take a look at the car lock on the right-hand side, which simply doesn't have any. There's nothing ornamental about it. It's purely functional, and so that is an example of a design patent that was rejected by the court. And of course, the product needs to have some sort of aesthetic element. That's again, you need to have some kind of embellishment, ornamental embellishment to the product in order to have design patent protection. And
the one we have there that is the satisfactory design patents, the famous iPhone, or one of the versions of the iPhone. And they get that design patent protection. I'm not sure this was the patent involved in the Samsung case, but it's exemplary of what Apple does. So, like design patents, they're good. Next option.
Next, trade dress. And trade dress protects the visual appearance of a product or its packaging, and that visual appearance indicates to consumers the source of the product. It's a species of trademark, and for that reason, we've mentioned this Converse Shoes registration, which consists of 2 stripes in the midsole of the shoe, design of the toe cap. Those are also, they indicate to the consumer that is a Converse shoe as opposed to a shoe from any other place. The advantages are that infringement is relatively easy to show, moderate expense. They are typically enforceable with takedown notices because, as I indicated, they are a form of trademark. They are covered by the Federal Lanham Act. They can, at least in theory, last forever. As long as you're selling the product, your trade dress / trademark protection will endure. And trademark registrations can be recorded with U.S. Customs. Which is, again, a terrific advantage because Customs can stop infringements at the border. Now, that said, there are some disadvantages. And Jeff, would you tell us about some of the disadvantages?
Yeah, it's hard to get trade dress protection. You know, when we think of trade dress, I like to refer to the famous Coca-Cola bottle as an example. Boy, a kid growing up in Connecticut, I remember putting in insulation in the attic, which was certainly necessary, and it was pink. And I grew up thinking my whole life that all insulation was pink. Well, it turned out not. That's actually Owings Corning, one of the very first cases involving can color be a protectable element as a trade dress, and they successfully did. So it turns out not all insulation is pink. Only Owings Corning insulation is pink. But so first of all, you need a registration to get the takedown notice. And getting a registration on trade dress is not easy because typically the two arguments you're going to get out of the trademark office, one is it's functional. Well, pink for insulation wasn't functional. And the other is you don't have what we call secondary meaning, that people don't recognize that element of your product is serving a source identifier. When Coca-Cola bottle, the bottle is functional, it holds the soda in it, and why would you think that when it first came out, it was anything other than a bottle? So you have to be able to show to the trademark office through sales and marketing and maybe consumer surveys sometimes that this is now people recognize it as an indication of source. It comes from a single source or a single authorized source. And you need to do a showing to the trademark office, typically by declaration. So it's slow to get protection. It isn't like my product's on the market, I automatically have trade dress protection. No, you have to develop in the eyes of the consumer or the consuming public that this is a unique, distinctive design. So you can't get protection right away, and then once you have the evidence, then you've got to go through the hoops of the trademark office. It typically takes at least a year to get a registration certificate. So there's nice pros, particularly the one that trademark rights last forever, but it's challenging protection to get. And did you go over the two examples we had there, Tom?
We had the Converse shoes that we discussed. We also discussed this folding chair that's purely functional, and thus it was rejected, invalidated by the court.
Yeah.
Great. Thanks, Tom. Thanks, Jeffrey.
Let me just back up on that a little bit. An example of where people often allege in a case trade dress rights, and where they run into problems is when I've done a deposition, but it doesn't have to be done. Deposition is you go through the product with the designer, and basically what the designer is going to say, I didn't make my product the best functional product I could be, and you play dumb. I'm an engineer, but you can play dumb and just say, okay, well, you did this because, why did you do that? Why did you do that? And at the end of the day, of course, he designed it for functional purposes. So this sort of takes us back to the next slide. Well, takes us forward to the next slide, which is recommendations and best practices. And our initial recommendation is try to build in protection into the product. So work with the designers and say, can you make this curve differently? Make it aesthetic rather than just a straight square curve or a typical round. Can we make it oval? Can you build into the product features that I can register as trade dress that maybe you got something copyrightable? Can we get a design patent on this? What can you do up front? And can you instead of designing a holder for a product and then part B that gets slipped in as your consumable, is there somehow you can make the connection unique so that we can get patent protection on the connection, and once somebody buys our handle, only our slip-in will work. So it's the upfront engineering and design will make the job of the legal counsel easier in trying to protect against 3D infringements and counterfeits.
Great, thank you. Transitioning slightly, I'd like to talk a little bit about what's currently out there as far as 3D marketplaces. So it's important to note that online marketplaces exist for users who are looking to design, print, and even sell their items. And so there are several out there at the moment. There's PinShape. We mentioned Thingiverse earlier. This particular example is highlighting shapeways.com. So Shapeways offers a platform for items that you can shop for as well as make. So users can actually go to Shapeways, design a 3D model using their tutorial that asks you to select which material, design every aspect of it. You upload this model to their platform, and they will print it in your selected material in your customizations, and they'll ship it directly to you. So this particular example, you can see that it's easy to see that trademark abuse is already prevalent, and these design, trademarks, and patents are also targeted. So if you do have the ample protection in place that Tom and Jeff just took us through, you will have grounds to remediate this issue on the 3D marketplace platforms. They're not unique to the eBays and Amazons of the world, and with the protection in place, you'll be able to take this down and actually solve this issue. So when we look at the internet, we really separate it into various sections. So we've seen 3D printing marketplaces already appear, and you can see here this is MarkMonitor's coverage of marketplaces in general. That does include 3D printing marketplaces. We also will probably begin to see a lot of independent websites popping up, as well as search engines. So there is a search engine out there right now called Yegi.com, and Yegi.com is specifically designed for 3D printed digital model files, materials, etc. It's a dedicated search engine for 3D printing in general. So it's important to not only look at the online marketplaces where people can get these items quickly, but look at websites, look at search engines, look at the chatter on social media. As this becomes more widely adopted, it's important to pick up on those trends. Mobile apps, we could see this coming through. PDP and file sharing, this is extremely relevant for 3D printing. As you're having these digital files created, it's very easy for them to also be uploaded and shared with users you may not want them shared with, which also allows for the marketplace. So these really are all interconnected. So it's important to not only look at one of these modules and one of these silos, but look across the different silos of the internet and keep your thumb really on the monitoring aspect. To really combine monitoring the internet, we combine strategic partnerships like the ones with Tom and Jeff, the legal counsel, and with brand protection experts. You're really building this comprehensive brand protection strategy that applies for 3D printing, applies for general brand abuse. So, don't just leave 3D printing to the side. Oh, it's not going to be widely adopted this year or next year. We're not going to worry about it. Worry about it today to put these in protections in place so you don't have a big problem tomorrow that we have to go back and remediate. So with that, Gina, I'll turn it back over to you. I think it looks like we have some questions trickling in.
Yes, we do. Let me just pull. Okay, so the first question is, does MarkMonitor cover other 3D printing sites or marketplaces other than the example that was shown?
So the short answer to that is yes. We highlighted shapeways.com, which we can harvest results from and take items down if need be. There's PinShape that we can monitor. Thingiverse we mentioned. There are probably about 15 or 20 independent 3D marketplace sites that we can monitor and detect infringement for and send takedown notices for.
Okay, great. So the next question, just pulling it up, what are the protections afforded by a design patent? Can a trade dress patent be used to extend a design patent?
Okay, this is Jeff Sheldon. The simple answer is yes. Trade dress patent can be used to, it's not exactly extend a design patent. Design patent expires, but it's a typical strategy. Get a design patent, and that gives you your exclusivity in the particular design, and then you can use that as evidence to the trademark office. Number one, that there are non-functional features, and number two, because you've had the design patent, nobody's infringed, that you have acquired distinctiveness, secondary meaning. And there's a specific example of that, which sort of relates to Mother Smoke when I was growing up in Connecticut, which is the Mogan David wine bottle shape. Was originally a design patent, and there was an issue of can they extend that through trade dress protection, and I think I think it was either CCPA, maybe it was Fed Circuit, said, yes, yeah, there are two different types of protection, and so effectively a design patent can lead to perpetual protection.
Okay, great. So another question that came in is someone mentioned, I think back when we were in the copyright section, that there was a contact for questions concerning registration. So who was it that you guys mentioned to contact for questions concerning registration?
I think we were talking about recordation and working with U.S. Customs, and I've been working with Ryan Tucker, who's part of, he heads up the team that Brittany's associated with, which is Strategic Services at MarkMonitor, and you're welcome to get in touch with Ryan, with Brittany, or with me, because this is something that we've been working on in developing a customs program that would work through MarkMonitor.
This is Jeff Sheldon speaking. The reality of customs recordation is it's nice, but that alone generally isn't enough. U.S. Customs only inspects a small portion, unfortunately, of what comes into the United States. And then the customs inspectors have books and books of registered things, trademarks, for example. And to expect them to remember them all is unrealistic. I mean, I found it effective if I got somebody in China saying, hey, guess what, infringing merchandise is coming in on such and such a ship and such a carton. Yeah, you give that intelligence to customs, they'll certainly act.
Sure.
Usually act on it, but to have them on their own rigorously enforce it, you need to do more, and that's what Tom was talking about with MarkMonitor.
Sure, and that's exactly why we do things like create these training guides, and both the concise versions, the ones that can be distributed to field agents, and why we go down and do customs training and this sort of thing. And that's exactly what we've been discussing with MarkMonitor. So feel free to get in touch with us on for any questions about that.
Yeah, I mean, at practical level, how does a customs guy know whether this is counterfeit or real? So you got to provide guidance.
All right, so another question that came in. In your opinion, has the need to show aesthetic elements in products led to more focus on design by companies?
Well, from my side, and I think Tom's going to agree, the answer is yes. But I mean, it's the input we give to clients for IP protection, particularly when they get us involved early in the project. But the same token, to distinguish products in the marketplace and I don't know what I'm sure there's a word for it that the designers use, but to make products easier to use and have the design lead to the function, we're seeing in the marketplace more and more products that have an aesthetic, non-functional element. I've got here's an example. I got a client with a product where it relates to padlocks, and made so you know where to put the padlock. He made the design of part of the element sort of in the shape of a padlock, sort of a built-in instruction. Is that functional? Is that aesthetic? You can argue it either way, but that's an example of where product design is going. Make things easier for the consumer.
Yeah. Well, certainly there's been a sea change in consumer products generally over the last generation, where design just plays such a critical role in selling products. So, and obviously your IP protections can be critical to that. I mean, obviously we see it. Jonathan Ives is a superstar at Apple, because Apple products are really beautiful products in addition to having great functionality. So and he's certainly not the only. Apple is certainly not the only company with just terrific design. So, for what it's worth. Okay.
All right, thank you.
Anything else?
Yeah, another question that came in. Do 3D printing marketplace platforms have takedown policies or programs like eBay's Vero program?
So the short answer to that is there's just not enough information really known. These 3D marketplaces are very new. So they don't have necessarily a built-out program like Vero where it's very sophisticated. They have a full team of people. They're dedicated to takedown notices. However, that doesn't mean to say that they don't have a means to take things down. So I'm assuming that what will happen as these platforms become more established is they'll, MarkMonitor, we have a relationships manager that works with marketplace platforms to really help them, understand what brands are looking for as far as takedowns and make sure we have a process in place to take these things off the internet. But I think that that'll develop over time as the 3D printing industry grows in general.
Well, they'll learn, because if they don't have a DCMA-compatible takedown program, then they can be sued directly for the infringement of whoever's selling on their webpage. You agree with that, Tom?
Yes, absolutely. The economic case is illustrative of that. Which is an example of a web. It was actually a web hosting service that was blatantly infringing both trademark and copyright rights, and was hit pretty hard as a result of its not only failure but its willful refusal to honor takedown notices.
Yeah, I think I just saw that judgment, jury judgment. Was like,
yeah, it was reduced somewhat by there were some issues with that judgment. It was reduced somewhat by the Ninth Circuit.
Okay, but it
was a big judgment, yeah.
Yeah, so the answer is if they don't have a suitable takedown program, then you can sue them directly, number one, and number two, they're going to learn very quickly they better have one.
Hey, Tom, can you name that case, the one you just mentioned?
Yeah, I get the spelling wrong all the time. So can I just send you a site to the case?
Yeah,
for distribution?
Work.
Okay.
Yes. So I'll just make sure that everybody receives that. So another question that came in, if I find a 3D printed replica of my product claiming to be the original, and I have all 4 discussed protections in place, is there one stronger than the other that I should consider using as a takedown reason first?
Well, the easiest is trademark. If they're using the name, the next easiest is copyright. If you have your registration, then I move on to the design. If you have a trade dress registration, that works, and then your last option is utility. And Tom, you do the takedown notices more than I do. Can you include more than one ground in a single notice, or you have to do them separately?
Well, we certainly do, and certainly with eBay, they're simply essentially forms. They're simply boxes to check. It's done through an API or done electronically. But yes, for the most part, you certainly can. It's really just a matter of what's easiest for this particular marketplace. Because we obviously want to make these as effective as possible and as easy for the marketplace to handle. But the answer would be yes.
All right.
Do we have another?
So, we just have time for a couple more questions. How often is counterfeit detected on these 3D marketplaces and e-commerce sites, or is the infringement mainly trademark abuse and brand confusion?
Daily. I guess the answer is daily. Tom, we got the patent protection for you on the installer, but you're dealing with that. I assume you're seeing, particularly in the Far East.
Sure, there's sure, infringement is a massive. It's a huge problem. I mean, it's something. According to U.S. Customs, it's something like 10%, on the order of 10% of global trade is in counterfeits. It's an enormous problem, and 3D printing is obviously an important component of that.
Your airplane you're flying on today may very well have some counterfeit parts on it. Scary.
And as far as what we're seeing at MarkMonitor as we scan and monitor the internet every day, the reality of 3D printed items is just we don't know how often it's detected because not a lot of brands are proactively monitoring these sites. And that's why, I do want to send out kind of an encouragement that we need to be paying attention more to these and being proactive. because we don't know much out there because hardly anyone's policing it at the moment.
Yeah. You know, if I can simply interject that for some companies use as essentially a form of brand protection as having exceptionally high value components that are not easily replicated, and 3D printing really puts pressure on that particular strategy because currently 3D printing is exorbitantly expensive in terms of you can't knock off a $10 item with a 3D printer right now. You can't do that cost effectively. But if there's an extraordinarily expensive component within your product and your brand protection consists or embodies having that component that can't easily be replicated, 3D printing is going to change the ball game.
Examples where I could see 3D printing is going to come up with hubcaps and car bumpers. Automobile companies try to design into those aesthetic elements to prevent the aftermarket industry, so that's an ongoing fight. But those are components that would lend themselves to 3D printing. Aircraft parts are, they're very expensive because whoever got the certification sort of has a monopoly, and those parts can lend themselves to 3D printing. And an advantage for the counterfeiter is they don't have to, they can sort of test the market and do onesies and twosies. They don't have to, build expensive molds. Once you got the hardware for doing 3D printing, you just take a digital file and you make whatever you want. So that's where we see the threat. Where particularly high value elements, mass-produced stuff, consumer products can be used with typical molding operations or extrusion. It's not going to happen. Well, right. I could be wrong. It shouldn't happen. I don't think it makes economical sense.
Okay, so another question that came in, are the digital models or files also sold online, and is there also a piracy element we need to be mindful of?
Well, I don't know if they're sold online, but if somebody creates their own digital file, in other words, they didn't pirate or copy your digital file, there's not. As far as I know right now, well, I take that back. The legal theory you would go after that is inducing infringement. In other words, the digital file is by itself, as we discussed, and using it yourself is not necessarily creating it by itself is not the infringement. But I guess I would argue, and probably be a case of first impression, if you're posting a digital file online to use to make something that infringes a design patent, I'd accuse the person of posting that digital file of inducing infringement. Now, how you get a takedown notice on that theory would not be easy. I mean, you could do a takedown notice, but how it would be honored would be a challenge. So I guess sort of two parts to answer the question. Yes, there's a legal theory, and I think it's a viable theory for inducing or contributory infringement, indirect infringement of whoever's posting that. And the second part is that type of situation does not easily lend itself to a takedown notice. Do you agree, Tom?
Yeah, I agree with that.
Okay, then we're right.
Yeah.
All right, great. That's all the time we have for questions. Sorry, was there more? Okay, yeah, that's all the time we have for questions. Thank you so much, Tom, Jeff, and Brittany. We appreciate you sharing all that great information with our audience today, and thank you, everyone, for tuning in. Thanks for the great questions. That definitely helped draw out more information for everyone tuning in. As a reminder, we'll be sending out a follow-up email with a link to the webinar's presentation slides and a recording within the next couple of days, so you can be on the lookout for that email. That concludes our webinar for today. Thanks again for tuning in, and have a great day, everyone.
Okay, thank you very much.